90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. My guest tonight is attorney Brian Andrew Tully, and he's the principal of the Tully Law Group. And we'll be talking about elder law and related issues that you should know, especially in light of COVID. Brian, welcome to Law You Should Know. Let's start out by just briefly covering the types of legal matters you cover and how they're especially pertinent as we recover from COVID.
Sure. Hello, Ken. It's great to be here. Thank you for having me. So we have what's typically called an elder law practice, and we focus tremendously on the care issues. So while an elder law practice may work through different types of planning and protection strategies and Medicaid benefits for their clients, we do that as well, but we also focus on advocacy and coordination of care issues. Now, in regard to the pandemic, what had happened was, as we all realized, the tremendous issues that fell upon the nursing facilities and our seniors. The care issues, were in the forefront of requiring assistance and guidance. So the amount of clientele that needed and new clients that needed assistance, just staying in touch with their loved ones within facilities or in assisted living facilities, the need was never greater. And now, just in the big picture, as we're dealing with the recovery, folks are really trying to stay home more as opposed to facilities.
So when you say stay home, you mean stay in their home as opposed to going to some other facility?
Certainly, yeah. So people like to age in place, as they call it, which means they always like to stay home. They always have. There was certainly a time and a place for an assisted living facility, and there is certainly a time and a place, health-wise and safety reasons, for a nursing facility. But when people have a choice, they're going to want to stay home.
And in terms of staying home and perhaps needing some care along the way, what type of options can you try to help them explore?
Mm-hmm. Sure. So the idea of receiving care in the home becomes an urgent matter because long-term care is not covered by our health insurance. The idea of long-term care is that it really is the opposite of medical care. When you go to the doctor or the hospital or a rehab center, Medicare or your health insurance is the primary payer. When it comes to receiving long-term care, your health insurance is not involved. Long-term care is going to be the things that we do every day. It's our activities of daily living, walking, bathing, toileting, dressing. So when we need help with those functional issues, we either have to pay for it ourselves, or we have to, if we have long-term care insurance in place already, or we have to rely on the Medicaid program. So when somebody needs help with these long-term care issues, there's informal ways to receive care through family, friends, neighborhood. And then as clients age and progress down the continuum, there's more formal ways of receiving care so they could stay there safely.
And unfortunately, Medicare will not pay for these services over the long term. If someone's wealthy and has long-term care insurance, it may help them. If they're poorer on Medicaid already, it may help them as well. If they're caught in the middle, then they have a problem.
The ones in the middle, yes, the middle class, as wide as that may be, certainly may run into problems because perhaps they didn't qualify or afford the long-term care insurance, and they're not yet that easily eligible for Medicaid benefits. So there is a whole process of planning and protection, strategizing so that we don't allow long-term care costs to make that family destitute.
And what can you try to do ahead of time? And how much lead time do you need? And when should people think about it for themselves or for their parents or relatives or friends or neighbors so that they can have that option?
Yeah, great question. So anybody that catches our webinars, I do webinars weekly sharing this type of information with folks, and they can be found on our website. But the number one recurring theme is folks need to do the planning and the protection in advance of the actual need for care. We never want to be caught off guard. We do not want to be involved in a financial or a care crisis. If there's a care crisis, you're always going to have less options. It's always going to cost more money, and there's always going to be more stress. So planning in advance is the answer. What we talk about with folks is dealing with the asset protection when you hit around 65 years of age. So in essence, when you get your Medicare card, that's when you should set up your elder care protection plan, as we call it.
Okay, and when you say planning, you're talking about planning to be poor or no longer have assets that would disqualify you.
Sure. It's definitely not planning to be poor. There's always
planning to downsize or give out your assets so you qualify.
You do, yeah. But there's ways to do it so that mom and dad or the clients keep control, keep flexibility. This is not about just giving all your assets to the kids and you're at their mercy. 100% the opposite. We have structures and trust vehicles where the client actually keeps control as to the trustee and the beneficiaries and what they can do and can't do. So, but yes, the overall concept of starting to reduce assets so that they can't be grabbed by Medicaid down the road is the idea.
And if someone finds out, unfortunately, they have an illness that may take a toll over the next few years or may put them in a situation where they need a lot of help, they may have to consider it sooner than the normal life cycle.
Sure. The idea of advanced planning is always the goal, but as we all know, we don't do that. So a lot of our clients come in with a need for care today. We have two different Medicaid programs that can help with the long-term care. One is community-based Medicaid, where a home care aide can go into the home after the application is approved. The other Medicaid program is what's called chronic care, which is for a nursing home. There are look-back periods and eligibility standards, which I'll be happy to get into. But if we're talking nursing home, there's a 5-year look-back period, which I can certainly explain. But gratefully, we're still looking at a home care process that's pretty fast. It's every Medicaid application is a bear. But as of today, as of this year, 2021, there are no look-back periods for community-based Medicaid for now.
And what does the community-based Medicaid provide if someone with your help should qualify for it?
Yeah, it really revolves around a personal care aide coming into the home to help your loved one with those activities of daily living.
Okay, so is that 24/7? Is that 2 hours a day, or it depends on their needs?
Good question, and we get that. I got that 3 times today. The community-based Medicaid application process is about the financial need, it's about the legal application, and it's about the care needs. There are going to be assessments towards the end of the process. The second assessment is by what's called an MLTC agency. It is their job to approve the number of hours of care. I have advocates on staff that help the client through those different assessments so that we can gain as many hours as possible. There's 3 potential scenarios when it comes to approval of hours. It can be hourly, it can be 24/7, it can be split shift, which is 12 hours and 12 hours. Split shift and 24/7, very, very hard to obtain. So the general approval is a 5 to 9 hour window on the hourly scale.
And of course, the family or friends might be able to fill in some of the gaps, or they might be able to pay for some of the gaps if they want their loved one to have more care.
Yeah, as I share with people, there's a continuum, and we use this in our office sometimes during consultations. A typical client, no functional decline, no cognitive decline, they're handling everything on their own. As they start to decline cognitively or functionally, the spouse or the children help. Then the next step is, again, maybe it's a neighbor, maybe it's other children getting involved. At some point, you need to bring in an outside person. Typically, what people do is they pay cash for somebody down the block. Not the best answer, but it's what happens. And then ultimately, you do end up with an agency, and you start realizing how expensive this can be, $300 to $400 a day for 24/7. So Medicaid becomes the natural answer to pay for the care because of the cost.
And what are some of the things that's, with your help, someone can do so they qualify for these benefits?
Sure. So Medicaid eligibility is about 3 things. It's about the assets that the applicant has in their name. It's about their income, and it's about their care level. If we have a need for care, we have to bring their assets down below a certain level. In 2021, it's $15,900 plus retirement account. On the income side for home care in 2021, it's $904 a month. Home care. Gratefully, we're able to shelter the income over the $904 with the use of what's called a pooled supplemental needs trust. So the idea is start the asset protection in your 60s, protect the home, get that into an irrevocable trust, which is a great tool, great vehicle for that, and then finalize the planning and protection as the need gets closer.
And let's just, if the home is held with a spouse, with a child, with someone else, do the same rules apply?
Generally, yes. When you have, it's interesting, the Medicaid laws actually say an applicant can own a home and apply for Medicaid and receive Medicaid. The risky part is you don't want them to leave that house vacant, because if they have to leave for a nursing home or assisted living, and you don't want them to die there without a spouse or a child living there. Once that house is vacant, then Medicaid can put a lien on it, or if they pass away, Medicaid can go recover against their estate. So a spouse being on the deed or a spouse living in the house will prevent that during that spouse's lifetime.
And what about after?
The ideal situation is to protect the house in advance with an irrevocable trust, get the house out of the potential Medicaid recipient's name into what we call the well spouse or into an irrevocable trust. If it stays within the names versus a trust vehicle or something called a life estate, then you're running the risk of lien, estate recovery, or another risk called right of election if the healthier spouse dies first. Okay. So there's risks if the house remains.
And what about other assets that might not be looked at? If someone has retirement accounts or other types, are there some types of accounts that are shielded from the eyes of Medicaid?
Yes, there are. So there's what's called exempt assets and non-exempt assets. And the easiest way to explain it is retirement accounts are those that are generally considered to be exempt. IRAs, 401ks, 403bs, qualified annuities. They are exempt as long as the applicant is taking what's called a periodic payment. And that's accepted to be the required minimum distributions once somebody hits 72 years of age. So as long as you're taking your payouts, then that retirement account will be exempt from the asset calculation, and you keep taking your payments, and then when you ultimately pass on, the beneficiaries inherit it. All other accounts, non-qualified money, checking, savings, CDs, investment accounts, stocks, bonds, mutual funds, life insurance, cash value, that all counts. Second homes, vacation homes.
If you have another name, if it's a joint account, are you assumed to own half of it, or is there any
Good question.
assumptions?
Unfortunately, the answer is no. All joint accounts are deemed to be owned by the applicant 100%. So they have to be dealt with in the application process.
I'd like to remind our listeners we're talking to attorney Brian Andrew Tully, and he's with the Tully Law Group. We're talking about asset protection and how it can happen to anyone, especially as they get older, if they have some unfortunate event, which may have included COVID, or they're, let's say, diagnosed with some disease which might cause debilitation over time. So as you mentioned, timing is important. It's important to consult with someone like yourself before these events, or right away if your loved one learns of some situation.
Yeah, absolutely. Most clients, again, they're coming to us looking for home care. But in that vein, most nursing home admissions offices and directors are great and very supportive. But we've had clients come to us after visiting a nursing home because their loved one needs care, and nobody at that nursing home said, talk to an elder law attorney. Nobody in that nursing home said, get some help. And nursing homes do actually receive a higher private payment from families versus what they receive from Medicaid once that's approved. So I don't know what the intention was in this one facility that I'm referring to, but they said, no, you just pay every penny, and then once you're broke, then you apply for Medicaid. And that's not necessary. If you have a spousal situation, all of those assets can go from the spouse that needs the care to the spouse that is staying at home. A spousal refusal document would probably be signed. If you do not have a spouse and it's a nursing home situation, then we're able to utilize a different strategy called the promissory note and gift strategy, where we can shelter roughly half of the remaining money. You do not have to spend it all.
And I think the takeaway is if any nursing home tells you will take your money for now, they should call you right away because that's not their best scenario.
It's not the best scenario. It may be the only scenario for the time being, but you need to plan and protect for what's going to happen next month or the month after. You may have to pay for some months. And again, you're not going to save every penny of it in a single individual situation. You're going to have to pay for some of it.
And someone may need that situation because of a sudden illness or accident.
Sure.
Or it may be some kind of progressive illness where they have a little time to set these things in motion.
Certainly. There's always the clients that are coming in that have had the unfortunate stroke, and there's a need for care after the rehab stay, or that's the more sudden example, or we're going to have our clients that have declined through the years through a dementia type illness or a Parkinsonian type of illness.
Okay. Now, I know that you're involved with other elder law issues besides nursing homes and setting up these trusts.
Sure.
Many of your clients, you've helped them with wills and power of attorneys and health care proxies. But let's focus on the power of attorney for the moment because there are new power of attorney forms coming to effect in 2021. Tell us what that means and why.
Sure. So a power of attorney, and as I tell my clients, is probably the most important document there is, or it certainly can be the most important document. New York State has always made the power of attorney process a little complicated. A power of attorney is where a principal, a person, can appoint an agent to handle their legal and financial matters. Crucial document. If there is no power of attorney in place, or if the power of attorney is lacking certain language, then a guardianship proceeding may be required, because once there's capacity lost and there's no legal document giving authority to somebody else, you have to go to the courts and have that person declared incompetent by a judge, and then a guardianship is awarded over the person for health care or the property for the finances. But that process is going to be expensive and time consuming, and it might not be even the person that you want to act on your behalf. 100%. You want to stay away from guardianship. It's an 8, 9, 10 month process. It can be $5,000, $10,000, $15,000 in cost. It's all avoided by having the right power of attorney in place. And again, as you asked in the initial question about this, the power of attorney law, we've had it in existence since 2009. It was tweaked in 2010, and it has been a very complicated document over the last 10 years. But last year, the governor signed a law changing that, kind of making it a little simpler. And that new form, power of attorney, became effective June 13th, last week, 2 weeks ago, a couple weeks ago.
So if you don't already have a power of attorney, it's important, perhaps with your assistance, to get the new form in place. If someone already has the old form, let's say they came to you a few years ago, or they already have a power of attorney, is that still valid? It
is. As long as it was signed properly and executed properly and supervised, and it has the right language. I can't stress that enough. I sit with a client at least once a week where they say, I've got my power of attorney, I'm fine, I don't need a new one. I need to see it and review it, because if they got that power of attorney from LegalZoom or from an attorney that does real estate closings only and does not focus on aging and elder care and asset protection, that power of attorney is going to be lacking and it's going to be insufficient. So it needs to get updated. So if you have a power of attorney in place, great, but you need somebody like ourselves to take a look at it and make sure it has all the right language.
And if you're doing one now, you need the newest language.
It has to be. Yes. Since June 13th, the new statutory form exists. There's places for modifications, and those modifications have to be inserted by the attorney preparing the form.
And just briefly, what are some of the areas covered by the power of attorney and some ways that someone may want to limit the power of attorney or not?
Good question. A general power of attorney that comes right out of the statute refers to banking transactions, real estate sales, personal property issues, insurance transactions, basic legal and financial matters. The modification sections that are in there once we're done with it deal more with aging, elder care, asset protection, income protection, establishing trusts, funding trusts, retirement accounts. We throw in the kitchen sink just because we want to make sure. Now, the idea of gifting and asset protection, that may hit a client a little awkwardly, and they may say, I don't want my child to make gifts, or I don't want my child to give money to themselves. So a discussion needs to occur with the client as to what their goals are. So we can always limit the types of gifts or to whom gifts are going to be made. It's important to realize, though, a gift in our world, in the power of attorney world, in the elder care world, is more than Christmas and holiday and birthday. A gift is about asset protection. So it's a gift. If we need to protect a $100,000 bank account, it's a gift. Whether it's to a trust or to a child, it's still a gift. So there's reasons to allow certain gifting authority.
And another important consideration with power of attorney, if you lose your mental or physical faculties, it's going to be impossible for you to understand and sign the power of attorney form. That's why you need it ahead of time.
Correct. Again, every adult should have a valid power of attorney, health care proxy, living will, and last will. In fact, I got 2 kids in college, and before they left last August, they signed a power of attorney and they signed a health care proxy. God forbid it's needed. Now, the power of attorney form itself, another great aspect of the new law, besides the simplicity, is that if there is mental capacity but a physical inability to sign, the new law actually allows somebody else to sign the form for you. And we've already used this in the last 10 days. It's a great way so that even those that don't have the mechanical ability to sign can still have the power of attorney if they have the cognitive ability to consent.
I just want to remind our listeners, we're talking to Brian Andrew Tully, and he is the principal of Tully Law Group. As you've heard, he's an elder law attorney. He deals with these trusts and Medicare plans or Medicaid plans, and also issues like the power of attorney and wills. And Brian, what is your website? We have other information available to our listeners.
Sure, thank you. It's Tully Elder Law, Tully, Elder, ELDER, law, LAW.com. My direct email is Brian, BRIAN, at TullyElderLaw.com. The website has good information on it. We've been doing blogs for years, and ever since the pandemic began, I've been doing webinars. So there's going to be close to 20 different webinars on our website under the video and webinar navigation tab, dealing with the changes coming for community Medicaid, the irrevocable trusts, the regular planning. We just did a webinar yesterday on supplemental needs trusts for families with disabled individuals. So there's a lot of planning information on those webinars.
And it's a way to get a great deal of free, valuable information about the law and people's rights and options.
100%, yes. It is all free. It's why it's there.
And I know that you also deal with the issue of wills and estates. Does someone need to review their will or update their will? And when do they need to do that?
Another good one, Ken. When a plan is put in place, great that it's in place, and great if you can review it and update it as needed. There's 2 guidelines. We like to say every 3 to 5 years it should be looked at. Sit down and review it at a minimum. The alternative is life events, births, deaths, illnesses, inheritances, retirement. As those things happen, your estate plan should be reviewed.
And I also want to say marriages and divorces or second
and correct. Any marriage and divorce, you should certainly be looking at your planning documents. When we do a trust plan for a family, we provide them with annual meetings, so we get to sit down and review these things.
And we talked a moment ago about the power of attorney. What should you do if a bank or a hospital or a nursing home says they want their own form used?
So another good aspect of the new law is that there is a process for a financial institution, for example. That's the primary place we'd use it, if they were to reject it or require their own. The new law actually gives some teeth to the idea that the financial institution has to accept your power of attorney, or they have 10 days to state in writing as to why they won't accept it. And from that period, an attorney can actually bring a special proceeding with damages against the bank for not accepting
to save that time and expense, should they get the bank's form and execute it while they're doing the general power of attorney that you prepare?
Ken, practicality is always a good way to go. And yes, if you're working with a Fidelity or a Chase and they want their one-pager, there's no harm. There's no harm in doing it. It's where push comes to shove is where capacity is already lost and we can't do that one-pager anymore.
You've been helping a lot of people as they cope with issues from the pandemic or concerns they had. How has the pandemic changed attitudes about wills or health care proxies and estate plans?
It has changed it. One of the most common words that we heard, unfortunately, last spring and summer was ventilator, respirator. We heard about that all the time. So people are aware of those terms and they're aware of the complications and the difficulty and the severity of being in that situation. So the idea of having a healthcare proxy is where somebody can make a healthcare decision for you if you can't. The idea of a living will is a general statement that says, if I'm in an irreversible condition, incurable condition, not getting better, I don't want ventilators, respirators, feeding tubes, but I do want maximum pain relief. So people are more, or they're relating to it more.
And to also make clear to our listeners, the Health Care Proxy and the power of attorney are tools that are valid while you are alive. You may not be able to exercise them physically or mentally, but once you pass on, they have no validity, and then it's all about your will or your trust and other documents.
Well said. Correct. And I've had clients say, well, I'm the power of attorney. I'll take care of it after dad passes. But like you just correctly said, the power of attorney ends when the principal passes on. And a corollary to that is I've had clients say, well, I have a will. I'm just going to, transfer the accounts to me after dad dies. The will doesn't work that way either. The will exists, right, as a document, but it is not technically a last will and testament until it goes through the probate process.
And your assets and your estate are frozen at the moment of death. You cannot start making changes then.
So there's different ways that people own their accounts. Those assets and accounts that are solely owned, meaning not joint with another, don't have a beneficiary, and are not in a trust, those that are solely owned, yes, they are frozen, and you can't touch them until the will goes through probate, or if there's no will, you go through what's called an administration proceeding.
And that would be true for your house too, if it was just in your name.
It is true. The house is a little different in that the law states that a house cannot go unowned, so it will always pass to the distributees, the heirs, but they're not going to be able to do anything with it until they have the legal authority to change the title. So that's where probate comes in.
So should people try, and probate is if you need the courts to help assist distribute your assets. If they don't have a plan from you, if they don't have a will, then it goes to the court to follow the statutory formula.
If there are any accounts or assets in the decedent's name alone, regardless if there's a plan or not, regardless of their net worth, regardless of their family, anything in their name alone requires court intervention. If there is a will, it's called probate. If there's no will, then yes, we follow what's called intestacy, which is where the state determines who inherits, but that's called an administration proceeding.
And if they have a will, generally, as long with some exceptions, your plan will be followed with certain caveats, which are very important. And if not, then it will go through the intestacy where the court is distributing your assets. Again, they're following certain guidelines, and they don't have flexibility. With your will, you have more control and more flexibility.
In that, yes, and that's because the client gets to determine who inherits and who's in charge. So that in a will, a client can say, this is my executor. If this person can't do it, then this person does it. In addition, you can say, I've got 3 adult kids and I got 3 minor kids. I want the 3 adult kids to inherit outright, but I want the 3 minor kids to have their inheritance held in trust until they're older. I don't want a 15-year-old to blow it. But that leads to another issue, Ken, in that if you have a minor, or if you have property outside of New York State, or if you have a disabled beneficiary, all the more reason to not use a will to distribute your estate, but to use a trust. Because those 3 scenarios, disabled child, disinherited child, or real estate outside of New York, is going to force the court to appoint, to require a second probate proceeding or to appoint a guardian.
And when you say use the word trust, just explain it very briefly. What does that mean?
Sure. A trust is an estate planning tool. It is nothing more than a written agreement between generally 2 people. You have a grantor who creates the trust and sets out the language. You have a trustee, that's the manager, and you have a third party, and that's the beneficiary, who benefits by the trust agreement itself. You have 2 main types of trusts. You have a revocable trust, which is not an asset protection tool. It is a probate avoidance tool. With a revocable trust, the client, the parent, is the grantor creator, is the trustee manager, and is the sole beneficiary. In an irrevocable trust, the goal is asset protection and probate avoidance. And that's where you have a child or somebody else as a trustee, and the beneficiary is broken up.
And if you set up the trust with an attorney's help, someone like you, you can name people to all these things. You can talk about who gets what and the conditions of the trust.
Correct.
Your way.
It's your way. And one of the main reasons we like to avoid the courts and use trusts is because it'll be faster distribution, it'll be less expensive distribution, and it will be private. Okay. When you're looking at a probate probate proceeding, everything is public. When you utilize a trust, everything is private.
Okay. Brian, I just give you your website one more time.
Sure. We're TullyElderlaw.com, Tully, elderlaw.com. Our phone number is 631-424-2800, 424-2800.
Keep in mind, the information you've heard from Brian Andrew Tully has been very good, but it's general information and not intended to constitute legal advice, and you should contact Brian or another qualified attorney for legal advice pertinent to your own situation. I'd like to thank you for listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, Long Island, New York, and please join us next week at 3 o'clock for another program on Law You Should Know, or listen to the podcast of this program or many other shows on Law You Should Know at nccradio.org.